Hello, this is Matt on the Moon Lambo channel, and here's a headline from crypto media outlet You Today. Ripple compares XRP to oil and diamonds in its response to the SEC's amended complaint. And so you may recall that the SEC legally filed their initial legal argument against Ripple, the original claim, on December 22nd, 2020. And then they found that perhaps we could have adjusted some things specifically to make it more clear that Brad Garlinghouse and Chris Larson knew that what they were doing was wrong, and so they filed an amended complaint because they failed the first time around. And even then, I covered it in another video, so I'm not going to really get into it in this one, but pretty weak sauce in my humble opinion. But so they filed that complaint, the amended one, and now Ripple has responded, and they're comparing XRP to oil and diamonds. And I'll tell you what, I kind of like the sound of that. The only problem is I think XRP is more valuable. Well, maybe not today. It could be at some point in the future. If XRP is actually globally adopted, things could be a-changing. But I do want to be clear that I don't have a legal background of any kind. I'm not offering legal advice. I don't have a financial background of any kind either. Did y'all know that? So I'm not offering financial advice. You should not buy or sell anything because of anything I say or write. I'm just an enthusiast who likes talking about Ripple and XRP and crypto-related topics. I make YouTube videos purely as a hobby. But I very much do appreciate all the support. And so you can see here, here's the quote in this piece. I don't want to go through this whole thing, but you can see here. Here's a quote from the response. Many entities own large amounts of commodities and participate heavily in the commodities markets. Exxon holds large quantities of oil. De Beers owns a large quantity of diamonds. Bitmain and other Chinese miners own a large percentage of outstanding Bitcoin. Exactly, and so the idea that XRP, which is simply computer code, represents a security in and of itself is outrageous. If you want to make the claim that Ripple sold XRP as an investment contract, that's actually a different legal argument, and maybe I've got some footing there, but the idea that Ripple shouldn't be able to sell what in and of itself is not a security moving forward, that's awful, and also be very bad for XRP holders, I believe, if that were to end up being the case. And I don't think it will, but I'm just saying if it were to be the case, not so hot. And then as long as XRP's allowed to be traded on exchanges in the United States moving forward, hey, on a scale of 1 to 10, 2 thumbs up. But outside of that, we do have some serious problems. So we'll have to see what happens, and that's why I acknowledge holding XRP is more risky than it used to be, but I really can't imagine a world, it's hard to imagine, right, anyway, that a world where XRP is actually deemed a security, and then if that's the case, what cryptocurrency other than Bitcoin isn't? Because there's always somebody you could target as a central authority, regardless of how decentralized a cryptocurrency is. If that doesn't matter anymore, yeah, anything could be. And so somebody named Major Danger here on Twitter tagged attorney Jesse Hines. I'm going to share. I got opinions from a couple lawyers in this video, actually. Excuse me. Tagged lawyer Jesse Hines and wrote, "Jesse Hines, my man, you were so on point. Sorry you got bashed by the haters." To which Jesse Hines responded, "Thank you." And what was he talking about here? Well, there was a thread between attorney Jake Chervinsky and Jesse Hines, which I highlighted in a previous video. Not going to go through that whole thing again. But just to summarize it, Jake, that's not his name. Jake had an emotional response, and even acknowledged in the thread that he was responding based on anger. And he was saying that he was basically claiming that Jesse Hines was doing a major disservice by just sharing his opinion. And mind you, Jesse Hines has always made clear that he's not offering financial advice. People should be able to share opinions. If it's not okay for Jesse Hines to share his opinion just because he's a lawyer, while offering a disclaimer, mind you, then what other conversation should we shut down? Like, what about television programs, think CNN or Fox Business, where they have panels and they're talking about the way the market's moving, because that could influence people. Should we just not have conversation? And if that were the case, how do you even learn anything, period? And so it was a silly argument. And nothing against Jake personally, just to be clear. I just didn't like the argument. And anytime, I don't care who you are, if you're coming at something from an emotional perspective, it's really not the good look, and it's not the best way to behave, but certainly nothing against him. And to his credit, in fact, he ended up apologizing for that. He recognized that. So I'm not saying this to, be rudely critical of them. That is not my intent. Actually, rather, what I'd prefer to do here is give credit where it's due. Like, I was impressed because how many of you, if you make a mistake like this in life and because we can all do it, right? You can react emotionally, and then you realize later on, I was like, maybe I shouldn't do that. How many of you actually go back and apologize? Well, Jake did, so that's why I'm saying, like, I'm impressed, frankly, and I say, bully for him. That's awesome. And she wrote, it was me being a jerk. I'm sorry. That's literally the quote. And so he still stands by his point from a legal perspective, which is that it has to do with due process, which is what I'm not going to get into, but I wanted to explain why I was highlighting that. And so this is a major defense from Ripple, and I want to run through this. Fourth defense: lack of due process and fair notice. And this is very interesting. It's having to do with exchanges that were approaching the SEC about XRP's legal status. Excuse me. It reads as follows. Ripple did not have, and plaintiff failed to provide, fair notice that its conduct was in violation of law in contravention of Ripple's due process rights. Due process requires that laws give a person of ordinary intelligence a reasonable opportunity to know what is prohibited. Here, due to the lack of clarity and fair notice regarding defendants' obligations under the law, in addition to the lack of clarity and fair notice regarding plaintiffs' interpretation of the law, Ripple lacked fair notice that its conduct was prohibited. And this is exactly what Jake Chervinsky was talking about. And even to this day, and it's fine that he and Jesse Hines have a different opinion. Like, we should encourage diversity of thought as long as people are being a genuine and we're not being ideologically biased, and as long as we're not emotionally driven. It's great to have different thoughts out there because somebody's right, somebody's wrong. Maybe they're both wrong, and there's a third idea we didn't even thought about yet. But we're not going to get to the truth if people are ideological and emotionally based. Emotionally basing their arguments. It's not a good thing. And so this continues now. Prior to the SEC's complaint, countless market participants for years transacted in XRP believing it was not an investment contract. XRP was listed on over 200 exchanges. Billions of dollars in XRP was bought and sold each month. Numerous market makers engaged in daily XRP transactions. Ripple's on-demand liquidity product was used by many customers, and XRP was used in third-party products, many of which were developed independently of Ripple. In short, there was no fair notice to the market that transactions in XRP violated the law, or that the SEC would later claim XRP itself to be an investment contract. And so Jesse Hines was on the other side of what Jake Chervinsky was saying, and he believes exactly what Ripple is citing here, which is that due process here, fair notice, it's a major legal issue, and he's not the only one. I've got opinions from Jeremy Hogan, another attorney. I'm sure many of you are familiar with this at this point, and he actually shares this opinion with Jesse Hines. So it seems like it's actually legitimately a strong legal argument, and given the bright minds that Ripple's hired to represent them from a legal perspective, I don't think they'd be putting this out as a major defense if it didn't have actual teeth. So sorry, guys. Let me take a sip of water. I don't know where that came from. Probably got a little bit of the Rona. The Rona. All right. Anyway, and so then they write, the lack of fair notice to Ripple and market participants was exacerbated when, in May 2015, Ripple entered into a settlement with the U.S. Department of Justice and FinCEN that described XRP as a convertible virtual currency, and that expressly permitted future sales and distributions of XRP, including in secondary markets, provided they were conducted by a money services business registered with FinCEN and in compliance with federal laws and regulations applicable to money services businesses. Upon information and belief, plaintiff knew of that 2015 settlement, and yet, for years after, plaintiff provided neither defendants nor the broader market with clear notice that in plaintiff's view, defendants' prospective XRP sales as permitted by the settlement agreement would nevertheless constitute a violation of another federal law. And so how do you sum this up? The SEC waited too long, and it's actually legitimately a legal problem for them. And you can think about it, even if you think, well, it's only been several years, which is, I don't think that's a good argument, but even if you say that, like, oh, so what if it were 20 years then? What if it were 30 or 40 or 50? And then the SEC is like, oh, you should have known for the last 50 years. At what point Do you recognize that it's ridiculous? Because to me already, even if you're just looking from 2015 and now they charge them in 2020, that's already ridiculous to me. And maybe that's subjective, but at what point would you agree it's ridiculous? What if they were conducting business for 100 years? And they're like, oh, wait, ooh, yeah, this XRP thing, this is a security. Yeah, no, that doesn't make any damn sense. And this is not like, obviously, again, I don't know what legally is going to stick. I suspect that the Ripple lawyers know what they're talking about. But from a logical perspective, I can speak on that. I got a damn brilliant mind here. I got Moon Lambo, damn it. And seriously, though, it doesn't make any damn sense here. And so, let me see. There might have been something I wanted to highlight here. Yeah, there's some more stuff. Just the other day, Jake Cervinsky was responding to Jeremy Hogan about how he just says due process. Basically, it's not going to stand here. Yeah, maybe. I'm gonna. I don't think I need to highlight this. Let's go into this. This is from Jeremy Hogan. I'll tell you what, lawyer extraordinaire, wrote the following. Ripple amended complaint. I'm not going to shoot a video about it because there's not much that's new, and I'm exhausted. The SEC amended complaint mostly added additional facts, re the individual defendants, but since it's a new complaint, Ripple had to answer it. And then he wrote, this is a 3-part tweet here, the amended answer / affirmative defenses changes parts of the opening statement to include new information about, quote, multiple companies, meeting with the SEC before and up to 2019, re the legal status of XRP. Some were exchanges, some were companies building out use cases for XRP. So they went multiple entities here. And no indication from the SEC that they should put the kibosh on it. And then Jeremy Hogan wrote the following. A lot of new information is added to affirmative defense number 4 related to due process and fair notice. Do not listen to anyone who says, arguing you got away with it for 8 years is not a good defense. The due process argument is key to this case. And so what's he talking about there? He says, don't listen to anybody that says arguing you got away with it for 8 years is not a good defense. Because that is basically what Jake Cervinsky was saying, right? Well, actually, literally what he was saying. In fact, take a look here. Here's what Jake Cervinsky tweeted out on March 4th. And then he put this in quotation marks. He wrote, we got away with it for a really long time. Actually isn't a viable defense to an SEC enforcement action, by the way. And so you have to differentiate, though, between, the SEC being unaware. Because think about it, if the SEC were actually unaware, like imagine there's some illicit activity with any branch of, the federal government or any sort of law enforcement entity. Yeah, you can get away with something for a long time, but then when they find out and start going after you, like, yeah, you're gonna be in trouble. But 8 years for this when they're operating in broad daylight, just forget the legal defense, because I don't have legal background, but just use your own mind. Logically, does that make logical sense? The answer is clearly no. The fact that they couldn't get their act together in 8 years, but they could go after other entities in 2017 that launched ICOs, they could launch it right away. No, I don't buy that one bit. It doesn't pass the smell test. And so when Jake Cervinsky wrote here, we got away with it for a really long time, that's actually the quote that Jeremy Hogan was citing there. So you've got Jesse Hines, Jeremy Hogan, and Ripple's legal defense team, which, by the way, has a former SEC chair on it and an SEC director. All those lawyers think that this is a legitimate defense. Jake Cervinsky feels differently. And I say that's fine. So again, to be clear, I encourage diversity of thought. I'm not persuaded. And again, I don't have a legal background, but I'm not persuaded by what he said, certainly from a logical perspective at a minimum. If he thinks that there's a legal case to be made, despite the fact that it's not logical, just outside of the legalities of it, I'm willing to be persuaded on that front. But I haven't seen a sufficiently articulated case to sway me in that direction here. And so I ended up tweeting here too, because look, Jake Cervinsky wrote to Iron Halo here, an XRP community member. I'm genuinely curious, where did you get the idea that silence equals tacit approval? To which I responded, I'd say the idea of tacit approval is artfully articulated in this document. Quote, Mr. Garlinghouse was inundated with evidence that defendants' transactions in XRP were not investment contracts. And that's from a document there, which I ultimately linked to. And I wrote, to be clear, it's not just about tacit approval from the SEC. It's about all the evidence a reasonable person could acquire indicating that XRP did not represent an investment contract. And because, look, if a reasonable person would have done it, like, why would all these United States exchanges be willing to trade it? Because from their perspective, it was just as risky to trade XRP as any other altcoin that they were already trading, because they're all in the same bucket. And that's why this is also so dangerous. But anyway, I'll go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.